Circumstances that increase or decrease the authority of a precedent. Precedents. Precedents, also known as legal precedent or case law, is a significant source of law in many legal systems, especially those based on the common law tradition. It means following past court decisions as guidance or authority when deciding similar cases now or in the future. More importantly, there is unity, predictability, and flexibility in the legal structure of the region. Here is a more detailed discussion of priority under the law. Nature of precedents. Precedents operates on the principle of stare decisis, which means to comply with what is decided. This principle requires courts to follow previous decisions that are relevant and involve similar facts. When a court decides a case, its decision becomes a precedent that subsequent courts will often follow when faced with similar legal issues. However, it is important to note that the criteria are not hard and fast rules, may be modified, reversed, or modified if circumstances or law require change. Hierarchy of precedents. In legal systems that follow the doctrine of precedent, there is often a hierarchy of courts. The higher courts, such as the appellate or the Supreme Court, have established several precedents that bind lower courts to the same decision. Lower courts are generally required to follow procedures established by higher courts and promote unity and consensus in legal decision-making. Definitions. Here we will discuss how precedents is defined by law dictionaries. Black's Law Dictionary. Precedent refers to a legal principle that requires courts to follow the rulings or decisions made in earlier cases with similar facts or issues. Bouvier's Law Dictionary. Precedent signifies that a former decision involving the same question and facts, and between the same parties or their privies, is a law or rule for the decision of a subsequent case, involving the same question and facts. Merriam-Webster's Dictionary of Law. Precedent is the practice of using earlier judicial decisions as a guide in deciding similar cases. Oxford English Dictionary of Law. Precedent is the legal principle of using past decisions or actions as a guide for making judgments in similar situations. Cornell Law Dictionary. Precedent is the practice of courts deciding current cases based on previous court decisions. Types of precedent. Precedent or legal precedent comes in many forms, each of which has its own importance in guiding the court's decisions and creating law. Below are some important factors and examples of their application. 1. Binding precedents. A binding precedent is a precedent given from a good court to the lowest court in the same decision that the court must follow. These decisions created the legal framework for interpreting the law. For example, the decision of the nation's highest court on legal matters is binding on all lower courts. Example: the U.S. Supreme Court's decision in Brown v. Board of Education, 1954, established that racial segregation in public schools was unconstitutional, affecting subsequent cases related to civil rights and education. 2. Vertical precedents. Vertical precedents refers to the courts in a hierarchical system. Decisions of higher courts affect lower courts' decisions. For example, in the United Kingdom, the House of Lords, now replaced by the Supreme Court, could overrule its own previous decisions, as seen in Practice Statement, 1966. 3. Horizontal precedents. Horizontal precedents involves cases decided by courts at the same level within a jurisdiction. These decisions are not binding on each other but can be persuasive. Example: America in the United States, different appellate courts operate at the same level. The district court's decision is not binding on other district courts, but its decision may be binding. For a persuasive precedents. Recommendations from other jurisdictions or courts at different levels in the same jurisdiction. Although they are not binding, they can influence the court's decision. For example, in the United States, the Federal District Court of California may refer to decisions in similar cases in the Federal District Court of New York for guidance. 5. Overruling precedents. Receiving the reward will have a higher judgment that the priority is incorrect and should not be followed. It replaces the previous one. For example, in the U.S. Supreme Court case Brown v. Board of Education, 1954, the principle of separate but equal established in the case of Plessy v. Ferguson, 1896, was overturned. 6. Distinguishing precedents. The court found that the facts of the present case are different from the previous one, which means that the court causes it not to follow jurisprudence. Example, in the case of Balfour v. Balfour, 1919. The court distinguished this case from future cases involving contractual obligations in an inherently special set. 7. Followed precedents. Following case law is the precedent that the court has consistently used in similar cases and established a line of judgment. For example, in England, the House of Lords decision in Donoghue v. Stevenson, 1932, established the modern law of negligence and was followed many times later. 8. Departing precedents. Departure from the precedent decision occurs when the court decides that there are important reasons for the deviation from the established norm due to the change of conditions or change of laws. Example, in Reversus R. 1991, the House of Lords, aware of social change, departed from the long-standing legal principle that a husband could not be accused of assaulting his wife, circumstances that increase the authority of precedent. The authority of precedent can be strengthened in some cases, which makes it effective on the execution of the decision of high legal future. The main situations that may give rise to the right of priority are: 1. High Court decisions. The procedures of the higher court, such as the Court of Appeal or the Supreme Court, have more authority. The High Court sets legal standards that can be applied to lower courts. Its decisions are considered more comprehensive and reflect general principles of law. 2. Clear and effective decision-making. Preparatory processes with clear, well-thought-out assumptions are preferred. Judges appreciate the explanation of legal principles and how they apply to reality. A well-reasoned decision reflects the reviewer's thinking and helps guide future events. 3. Unanimous decision. The fact that all judges in the court agree on the conclusion and opinion strengthens the precedent. Conflict means that there is an agreement among legal experts that makes the precedent more reliable. 4. Recent decision. Last procedures have more authority as they relate to modern legal interpretation. Legal understanding continues to evolve, and recent decisions reflect judges' current view of the law. 5. Application of fact. When the truth of the precedent is similar to the truth of the present case, the law is improved. Similar situations lead directly to a relationship and are suitable as a guide. 6. Correlation with other precedents. Precedents that follow existing laws and previous decisions will be more respected. The correlation between legal systems creates a reliable basis and strengthens the understanding of law. 7. Eminence or landmark cases. Precedents set in eye-catching or landmark cases have higher authority as they are important for the development of law. Such cases often involve important legal issues and attract widespread attention. 8. General decision-making. Administrators in decision-making bodies with greater influence, such as federal courts, have more authority. Higher-level decisions affecting a large area or many states have greater impact. 9. Clarification of legal doctrine. Precedents have been adopted that clarify unclear legal principles or resolve long-standing legal problems. Provides clarity and guidance in areas of uncertainty. 10. Application in numerous situations. When a precedent is used repeatedly on many occasions in different contexts, its authority increases. The repeated application demonstrates its enduring relevance and influence. Circumstances that decrease the authority of precedent. The authority of a precedent, or how much power it holds in guiding future decisions, can be diminished under certain circumstances. Here are some factors that can decrease the authority of a precedent. 1. Different facts. When the facts of a new case significantly differ from those of the precedent's authority diminishes. Courts rely on precedents with similar factual scenarios as they offer more relevant guidance in legal decision-making. 2. Outdated legal principles. Precedents might lose authority if they were based on legal principles that no longer align with current laws, societal values, or technological advancements. Courts prioritize up-to-date legal reasoning. 3. Contradictory decisions. In cases of conflicting decisions from different courts or jurisdictions, the authority of a precedent may weaken. Courts may choose the precedent that best aligns with their legal framework or prevailing legal standards. 4. Evolution of law. Legal doctrines evolve over time, reflecting societal changes and legal developments. Older precedents might lose authority if they conflict with newer decisions that better reflect current legal understanding. 5. Changing societal values. If a precedent conflicts with contemporary societal values, such as human rights or equality, courts might reduce their authority to ensure just outcomes that align with present-day standards. 6. New legal arguments. If novel legal arguments or interpretations arise that were not considered in the original precedent, courts might question the precedent's applicability and consider alternative viewpoints. 7. Critiques by legal scholars. When legal scholars offer well-founded criticisms of a precedent's reasoning or conclusions, courts may be more cautious in relying on it, especially if alternative perspectives are well argued. 8. Overruled precedents. If a higher court overturns a precedent in a subsequent case, the precedent's authority is significantly diminished. Lower courts are no longer bound by it, and it loses its status as guiding law. 9. Technological advances. Precedents established before significant technological advancements might be less applicable to cases involving new technologies. Courts consider the impact of technology on the legal scene. 10. Change in culture. A change in culture and practice will cause the court to re-evaluate the validity and authority of the old system, especially if they do not follow the current culture. 11. Poor reasoning. A vague explanation of the conclusion or doubt of reducing the law. Courts prefer precedents with strong and clear legal justifications.